Hi there. My name's Alex. Judge Lamb is going to talk with me today about the Provincial Court of BC, where he works.
That's right, Alex. In order to answer your question about where the case you've been studying will be heard, we have to talk more about the Provincial Court and the type of work it does. The first thing to know is that the majority of BC's court cases are heard in the Provincial Court.
Really? So, Provincial Court must be very busy if it hears so many cases.
Busy, yes. About 145 provincial court judges hear approximately 130,000 civil and criminal cases each year in 88 different locations around the province.
How would I address a judge in court?
Judges are addressed as Your Honor inside the courtroom, and outside the courtroom as Judge followed by their surname. So, for example, Judge Smith.
I noticed that you have a black and red robe on. That's what you wear in court, right?
Yes, I do. It is the traditional court attire for a provincial court judge. People's lives are affected in significant ways in the courtroom, so the formal attire reflects the seriousness of the court proceedings. Lawyers do not wear robes in the court, although they do in the Supreme Court.
So, should I wear something special when I'm in court?
No, it's not required, but if you have more business-like clothing, it's a good idea to wear it when you come to court. It's a way of showing the judge that you respect the court process and that you understand that a court is a more formal setting.
So, when can I watch these cases being heard in the Provincial Court?
Well, the judges hear cases in the courtrooms from 9:30 to 12 and from 1:30 to 4:30 Monday to Friday. Court proceedings are open to the public and anyone has a right to attend. It's an important way for the courts to be accountable to the members of the community. The registry for filing documents is open from 9 a.m. to 4 p.m.
You said that there are civil and criminal cases. Do you hear both types in Provincial Court?
Yes, there are four main categories of cases in the Provincial Court: criminal and youth, family, small claims, which is the name for civil cases in the Provincial Court, and traffic and bylaws.
And the Provincial Court hears criminal matters?
That's right. About 99% of all criminal cases in BC begin and end in Provincial Court. A much smaller number of criminal cases are heard in the Supreme Court. It is Supreme Court that hears all the jury trials. In the Provincial Court, judges sit alone. They never sit with a jury.
What about in murder trials?
In murder cases where an adult has been charged, we hear a sort of mini trial called a preliminary inquiry, where we're only deciding whether there is enough evidence to justify holding the full trial in Supreme Court.
What about if a 14-year-old commits a murder? What happens then?
The Provincial Court hears virtually all criminal cases involving youth from ages 12 to 17, and that would include a charge of murder.
Okay.
Children under 12 cannot be charged with a criminal offense. Although if it is believed that a child under 12 may have committed a serious crime, the family court and provincial court can conduct a hearing to consider the child's safety and well-being and whether they're being cared for appropriately.
How about shoplifting? Do you hear those cases too?
Yes, the court hears trials of crimes such as theft under $5,000, which is the formal name for shoplifting. We also hear trials for mischief, simple assaults, and more serious crimes like aggravated sexual assault or kidnapping, where the person charged or the accused chooses to have their trial in this court. If the accused is proven guilty or pleads guilty, then the court does sentencing hearings.
You said earlier the accused can choose where his trial is heard. What does he choose between?
If the accused person is charged with a more serious crime, such as manslaughter, breaking and entering, or kidnapping, the accused has the right to choose to have a trial in provincial court or Supreme Court. This is called an election. If the accused elects to have a trial in Supreme Court, then the provincial court conducts the preliminary inquiry we discussed earlier to see if the Crown has enough evidence to hold a full trial.
Why would the accused care where his trial is heard?
The accused may want to have a trial in Supreme Court because he wants a jury to hear his case, or else he or she may believe the chance to have a preliminary inquiry will help them learn more about the case against them.
You always hear reporters on the news say alleged when talking about a criminal offense. What does that mean?
Well, you've probably heard the expression innocent until proven guilty. In our system, an accused person is presumed to be innocent until proven guilty. To be proved guilty, the evidence presented by the Crown must establish beyond a reasonable doubt that the accused intended the criminal conduct and actually committed the alleged act.
So what about the case my class is studying where a person was injured when he got hit by a drunk driver? Would that case be heard in provincial court?
If the Crown charged the driver of the other car with impaired driving or driving over .08, then the trial would almost always be held in the provincial court. Although in a case involving death or where the accused has prior convictions, the Crown could proceed in a more serious way that would allow the accused an election for trial in Supreme Court.
So the drunk driver would have to be charged with the offense, and then there may be a trial if he pleads not guilty, right?
That's correct. It would be up to the Crown to decide whether or not to charge the driver.
You said earlier that there's a family court within a provincial court. What types of cases are heard there?
Family court helps families solve problems where children have been neglected or abused and problems arising from a family breakup. The provincial court hears about half of all family matters in the province.
Does that include divorce cases?
No. If a case deals with divorce, adoptions, or the division of family property, it will be heard in Supreme Court. If a case involves custody, guardianship, access, or child support, the case can be heard in either trial court. If it involves child protection, where the state alleges children have been neglected or abused, then the case is only heard in provincial court.
But not all family cases go to trial, right?
No. These days, far fewer cases get to trial. The large majority of family disputes in the provincial court are resolved by agreement between the parties with the help of lawyers and resources such as parenting education courses, meetings with family justice counselors, and mediation by mediators and by judges.
You said that there were small claims matters in provincial court. What does that mean?
This means that the court hears civil cases where the person suing is claiming $25,000 or less in damages.
What's the advantage of having your case heard in small claims?
The court is set up with simple rules using plain language so that people can represent themselves and save money, although they are welcome to have a lawyer. Additionally, fees for filing a claim are less and the trials are shorter, so there are fewer legal costs.
What factors do judges have to consider if a civil case gets to trial?
In a civil case, the judge considers the legal rules that apply to the dispute and listens to both sides of the case in order to decide which version of the facts is more probable.
That's what it means when a civil case is decided on the balance of probabilities, right?
Yes, that is the legal term for what's called the burden of proof in a civil case.
If you went to small claims in a provincial court, could you have a civil jury?
No, there are no civil juries in the provincial court.
So then what type of cases are heard in small claims?
Well, with a few exceptions, the provincial court hears most kinds of civil disputes, such as claims for debt or damages, construction disputes, personal injury claims, recovery of personal property, or enforcement of agreements or contracts involving personal property or services.
Can I sue for damages regarding the purchase or sale of a piece of land?
Yes, if you are disputing a breach of the sale contract. But if you are seeking a change in the title to the land, you would have to go to Supreme Court. If you are making claims involving builder's liens, bankruptcy, wills and estates, libel or slander, or if you are suing the federal government, your case will be heard in the Supreme Court.
There are cases where individuals actually sue the government?
Yes, citizens can sue the provincial government in either trial court or the federal government in the Supreme Court or another court called the federal court. If Jones were suing the government, the case will be called Jones versus Her Majesty the Queen.
Her Majesty? What does the Queen have to do with anything?
The Queen is the head of state in Canada. If the government is sued, her name is used.
Okay. So say you wanted to settle your case in provincial court. Can that be done?
Yes, a large majority of the cases settle without a trial and can be settled at any time during the proceedings. Small claims court holds a settlement conference with a judge or a mediation with a non-judge mediator in every disputed case. If the parties are unable to agree on a resolution and the case has to go to trial, then there may also be a pre-trial conference so that everyone is clear in advance about the legal issues and how the trial is to proceed.
Now, what about the case my class is studying where a person was injured when a drunk driver hit his car? Would that case be heard in small claims?
It would depend upon the amount of personal injuries suffered by the person who got hit by the drunk driver. If the amount claimed for personal injuries was for $25,000 or less, it would have to be filed in the small claims court. If it was for $25,000 or more, the case would have to be filed in the Supreme Court.
So that means the amount of damages is a very important factor in determining where a civil case is heard?
You are really starting to understand the court system, Alex.
I think I am. One part of the provincial court that I know a little about is where you can argue tickets.
That's right. It's traffic and bylaw court. This is an even more informal part of the court where you can act as your own lawyer to dispute a traffic ticket for infractions like running a red light, speeding, or for parking violations. You can also dispute bylaw offenses such as walking a dog without a leash.
Do judges hear those cases?
No, most often, judicial justices of the peace will hear those cases. They are judicial officers of the court and also hear applications for search warrants and for bail.
If I want more information about the Provincial Court of BC, where would I look?
The Provincial Court has a website which offers lots of information for the public. It will help you to learn more about the court generally or give you more specific information such as how to start a small claims action. Go to www.provincialcourt.bc.ca.
Thank you very much, Judge Lamb, for speaking with me today about the law in the Provincial Court. I think now I'm going to go and talk with the Supreme Court judge to find out what happens there.
That's a good idea. Good luck with your course.
Thank you. You can learn more about the BC court system by exploring additional resources on the Law Courts Education Society's website. If you're curious about the Supreme Court of BC and the Court of Appeal for BC, there are videos on this website to help you understand how those two courts also work. And teachers and students should check out the teaching guide and handouts.